Just walk us through these two big decisions and what they mean.
Okay, so on the Cy Vance case, on the New York grand jury case, and on both of them, by the way, it means we're not going to see any of the president's records immediately, maybe not even before the election. It's going to take months and months for this to work through the lower court. So that's the sort of top line here. Now, in terms of the specific cases, the court basically dismissed the president's two arguments that he's absolutely immune from any part of the criminal justice process because the sitting president can't be indicted. And if you unleash all the local prosecutors, presidents would be harassed. What the court said is the president now, with those absolute claims gone, can go back to the lower courts and make the same kind of claim anybody else would on why a subpoena should be quashed or changed. He can argue the same thing any other citizen would. He can also argue that having to put up with this from a state prosecutor would be harassment or would take too much of his time. In other words, sort of a little bit of a reflection of his argument there. But it's a win for the prosecutor because it says the prosecutor has a right to see this. The president is not immune to it. Take some time to work it out. Now, on the congressional one, as you say, this is more of a mixed victory. What they say is the president can't absolutely stiff Congress. But on the other hand, Congress can't just have anything it wants. So that there's a test that the lower courts have to apply. They have to say, is the information they're seeking available from some other source? Is the subpoena too broad? And remember, that's one of the problems here that the Democrats had. These subpoenas were so broad, seeking years of information from not only the president, but his relatives, other people who work for the Trump organization. Thirdly, does it serve a valid legislative purpose? In other words, does Congress have, in essence, the right to see this? And finally, would this be too much of a burden on the president to respond? So it's going to take months for this to work through the lower courts. But both of these are, in a sense, landmark rulings because they both try to set out what basically the terms are for when a local prosecutor or Congress can seek information from a sitting president. And bear in mind here, one of the things that made these cases a little bit different is none of these requests are for material from the president himself. They were directed to his accountants and his banks. And secondly, very little of it applied, well, none of it applied to the president's official duties, and very little of it applied to the president's time in office. So for all those reasons, these are important cases. They will undoubtedly set precedent for years to come when there are similar requests for material from sitting presidents.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.